If it pleases the court, my name is Jahar, initial T, and I appear as junior counsel for the respondent Queensland Mining. Queensland Mining is the respondent in these proceedings and the former employer of the applicant, Hugh Grant. Mr. Grant was dismissed for misconduct on the 1st of January 2017. Queensland Mining respectfully submits to the court that it has acted in the utmost good faith in accordance with the law and the terms of the employment contract between itself and Mr. Grant, and that all costs associated with this action are borne by the applicant. We refer the court to the judgment in Millers v Westrac Cat Proprietary Limited and respectfully submit that the applicant is precluded from bringing an unfair dismissal claim as he fails to meet the prescribed requirements for standing under Section 382 of the Fair Work Act, principally that Mr. Grant is not covered by any award and he is classified as a high income earner by the Fair Work Act. Section 48 of the Fair Work Act states that a modern award covers an employer, organisation or outworker entity if the award is expressed to cover the employer, organisation or outworker entity. We respectfully submit that Mr. Grant's role was one which is characteristic of a senior manager. The facts show that by his own admission, Mr. Grant had in his role as mine manager the last word on staffing levels, a function which is to be expected of a senior management role. We submit that there is no classification within either the Miscellaneous Award or the Mining Industry Award of 2010, which is characteristic of the senior management role held by Mr. Grant. We request that on the facts and in the spirit of the judgment in Leighton v North Goonyella Mines Proprietary Limited, this court finds that the role performed by the applicant is not covered by any award. The continuation of Mr. Grant's employment with Queensland Mines after the fixed term expired is evidence that both parties agreed to the continuation of the terms of the original employment contract in the spirit of O'Connor v the Argus and the Australian. An express term of this employment contract is the guaranteed base salary of $160,000 payable to Mr. Grant. This level of annual remuneration exceeds the prescribed threshold in Section 333 of the Act, which is currently at $138,900, conferring upon Mr. Grant the status of high-income employee under Section 329 of the Fair Work Act. On the basis of the above submissions, we request that the court find Mr. Grant has no standing to claim unfair dismissal as he is a high-earning employee with no award coverage. Should this court disagree with the submissions above and find the applicant has standing under the Fair Work Act to claim for unfair dismissal, we submit that Queensland Mining acted within the confines of the written employment contract between themselves and Mr. Grant, and we refer your honour to Clause 11 of the employment contract, a copy of which is tendered to the court. Clause 11.1 of the employment contract confers upon Queensland Mining the express right to terminate the employment contract upon good cause. We submit that Queensland Mining had good cause to dismiss Mr. Grant in that Queensland Mining's safety legislation demands underground mine workers retire at 60 due to safety concerns regarding their capacity to self-rescue. Mr. Grant was past this age at the time of dismissal, and his dismissal on these grounds is in accordance with statutory legislative requirements. I would also like to draw the court's attention to the ruling in Qantas Airways v Christie, where it was found that if retirement at a specific age is an inherent requirement of the role, an employer can legally seek to dismiss an employee on the basis of their age. Queensland Mining also submits that the reduction of funding by head office for Mr. Grant's role constituted good cause, and that by exercising their rights to terminate Mr. Grant on the basis of this good cause, Queensland Mining acted in a manner consistent with its contractual rights to promote its legitimate interests. We refer this court to the decision in South Sydney District Rugby League Football Club v News Limited. We submit that Queensland Mining was simply exercising their rights to terminate Mr. Grant for serious misconduct under Clause 11.2, as Mr. Grant has willfully neglected his duties and consistently and repetitively breached Queensland Mining policies and instructions in the discharge of his duties as an employee. Number one, Mr. Grant refused to carry out instructions on 2 different occasions. In the first instance, management assertively made their views to Mr. Grant known in relation to his refusal to act as directed. However, management made the decision not to take any disciplinary action as it considered the breach minor on its own. When Mr. Grant chose to ignore the express instructions of Queensland Mining a second time, this act by Mr. Grant was viewed by Queensland Mining as willful disregard for management instructions, and in conjunction with the first instance of disobedience by Mr. Grant, these acts had the cumulative effect of showing complete disregard for the obligations imposed upon Mr. Grant by his employment contract with Queensland Mining. We request that this court refer to the judgment in Hill v Compass 10 and find that Queensland Mining exercised their contractual right to terminate for these repetitive breaches of Queensland Mining policies and instructions. Mr. Grant also discussed confidential business matters with the union, which Queensland Mining views as a case of serious misconduct. We submit that on the rule in Bartlett v ANZ Bank, Queensland Mining does not need to prove the guilt of Mr. Grant. The mere fact that Queensland Mining holds the opinion that Mr. Grant is guilty of serious misconduct is sufficient for dismissal. We submit that the court finds Queensland Mining has legally summarily dismissed Mr. Grant for serious misconduct. Failure to meet the KPIs for coal sales by Mr. Grant would have had severe consequences for Queensland Mining, and in the spirit of Elcom versus Electrical Trades Union, we request that this court finds Queensland Mining simply exercised their right to terminate the employment contract as prescribed in Clause 11.3 of the employment contract, and that the counselling offered to assist Mr. Grant in reducing costs was ignored by Mr. Grant, leaving Queensland Mining no option but to terminate Mr. Grant's employment. Queensland Mining submits that the notice given Mr. Grant was sufficient in writing and the payment to Mr. Grant of all entitlements was in accordance with the relevant statutory legislation. Mr. Grant was notified by text message initially and subsequently in writing by Queensland Mining of his dismissal. We submit that per Gurgis v 1012, a text message is sufficient for the statutory requirement of written notice of dismissal. As it is Queensland Mining's submission that Mr. Grant was guilty of serious misconduct, under Section 123(1)(b) of the Fair Work Act, the minimum period of notice prescribed by Section 117 of the Act does not apply, and the notice given by Queensland Mining to Mr. Grant of his dismissal was sufficient. Queensland Mining was generous in their payment of 2 weeks' pay in lieu of notice and submit that any further payment for age or continuous service is not required due to the point made above, and that Mr. Grant was dismissed primarily on the basis of serious misconduct as submitted. If it pleases the court, these are the respondent Queensland Mining submissions.